death, taxes, life insurance, probate. Today I'm going to be talking with Seth, who is an attorney here in Los Angeles, and we are going to discuss one of the many things you need to consider in planning for your future, trusts, and the avoidance of probate.
Thanks for having me.
Yeah. Everybody, I'm Corrie Sommers. Stay tuned. We'll be right back diving into several topics. You're going to want to take notes or save this video because this is one you will want to reference in the future. If you haven't subscribed to my YouTube channel yet, as you're getting ready, go ahead and click the subscribe button and the bell for updates. Hey everyone, it's me, Corrie Sommers, your local Los Angeles realtor. Today I am here with Seth Beer, an attorney in Los Angeles. We are here in his office, in case you're wondering what this background is. And we are going to talk today about the importance of estate planning, establishing a trust, avoiding probate, which is not my favorite word, and some people very scary, but don't be so scared. I want us to kind of dive in, and I know we've done presentations before, so you have so much great information, and I don't want this to be too long of a video. I have a couple questions, but why don't you first just explain what a trust is, sure, why it's important, okay, and then we can talk about my unfavorite topic, probate, and my opinions on that, and the reality versus opinion.
It's almost a four-letter word.
Right? Yes. So define a trust.
Okay. A trust, it's kind of simple. It's really just a private agreement between whoever's setting up the trust and themselves. It's really all it is. And it sets up fiduciary relationships. It accomplishes a lot, but in its basic essence, it's just a private agreement.
It's just a private agreement. But it also offers some protections, correct?
It does.
Okay. I know many of you out there watching, you've heard things like the Rockefellers have become wealthy through trusts and, putting life insurance policies into those trusts. What exactly can go into a trust? And what are the most common things that are in a trust?
Sure. Well, what I do, most estate planning attorneys, we set up revocable living trusts for families, individuals, to help protect them, their decisions that they're going to make in their lives, their assets, and their loved ones. That's why we set them up. When you talk about the Rockefellers, those are very different types of trusts.
And more complicated.
They are. There are special life insurance trusts called ILITs. There are a variety of different types of trusts. But what we focus on mainly with our local families are revocable living trusts. And what they do is, one thing is probate avoidance, and we can go into that in some detail, but it allows you to, well, one of the biggest things you have to do when you have a trust, you get this document, hopefully it's a great document, has all your wishes, follows everything, makes sure your goals are accomplished, anything you're worried about is canceled out. You don't have to worry about it, but once it's set up, you have to fund it. You have to retitle your assets into the trust. If you don't do that, you're going to spend a bunch of money and end up, we like to think of a trust as a treasure chest. You got to put all your stuff into it once it's set up. When I draft it, it's an empty box. So you have to fill it with all your assets, your treasures. If you don't do that, you have an empty box that goes to probate. So
let's talk about the trust in the treasure box. So if you are someone and you're setting up a trust, and let's say you own a property, you now have to put the trust on the ownership. You change the deed, or you file a new deed.
You file a new deed, retitling it. We do that for our clients with bank accounts, investment accounts. Those I can't do that for people. They have to go into the banks usually or sign things. We help as much as possible. I advise clients put everything they can. Retitle anything that has a title.
401k,
No, you can't do retirement accounts.
Okay.
So any sort of retirement account has to stay in an individual's name.
Okay.
But you can name the trust as a beneficiary. And that way, when you're planning, and let's say you have everything going to your spouse and then to your children, it goes into the trust and then distributed how you want. Usually, if you just name people as beneficiaries, you can't really have many backups. In a trust, you can set it up so if something, God forbid, happens to one of your children, then their children get their share. And you can decide who's going to watch over it. You can pick the trustee, so it doesn't have to be your child's spouse, whether you love them or not. Money changes people, so having these different options and making sure what you want is in there. The trust allows you to really lay out things that if you just name beneficiaries straight out, you can't do.
So I'm going to give some examples and you can tell me the correct way if I'm wrong. So let's say I self-trade stock for retirement. and I have a Robinhood account and an E-Trade account, I would need to go to each account and name my trust as the beneficiary of those accounts.
If they're just investment accounts, you can retitle them into the name of the trust.
Okay.
So that way, when you have a trust, these revocable trusts, what we're really doing is planning in case you ever become incapacitated. And that just means you can no longer manage your affairs. And a lot of us think that's always age-related, dementia and Alzheimer's. But
It could be an accident.
a car accident, a stroke, any age you can become incapacitated. So we make sure anything that's in the trust can be managed by the people you choose if you're incapacitated, or distributed how you want when you pass away. So those are the two we call life events. It doesn't sound so horrible to talk about incapacity and death, but those are the events we set everything up for. So if it's titled in the name of the trust, you have incapacity and death planning. Everyth's covered. If you're just using a beneficiary designation, that only kicks in when you pass away. Then that asset goes into the trust and is managed how you wanted it to be.
Okay, so this brings a couple. So first example, you add the trust to those types of accounts. But let's say you have a Roth IRA or a 401k. In those cases, you would have to name the trust as a beneficiary because of retirement accounts?
Yes.
Okay.
And
Yeah, no, please.
Interrupt.
More info as possible.
When you're doing that, you have to look at who's next in line to get it. So between spouses, usually you want to name a spouse directly.
Right, of course.
They have an advantage over most people having a lifetime stretch of this retirement account, where most other people are only going to have 10 years, in which at the end of 10 years they have to empty the account, which has big income tax consequences.
Okay. Now, life insurance policies. If you have a policy that is a death benefit payout, then the beneficiary would be the trust? Or would you add the trust to the policy?
You can't. So you can have a trust own a policy, but that's a different kind of trust.
That's what we were talking about earlier.
Yeah.
We'll put that aside. We'll talk a little bit more about that.
Depending on what you want done with the money in the life insurance. So if you're using that to pay immediate expenses, it takes a little while to get everything into the trust and that. So maybe you want it distributed immediately to somebody so it can cover funeral costs, different things like that. But it really depends on what the person who's doing the planning wants, whether you use the trust as a beneficiary or people.
Yeah, because obviously some people, and I'll use my mom as an example. Oh, sorry, Mom, I know you don't like me saying stuff like this. Some people, like my mother, may have the type of life insurance policy that's just going to cover their funeral and nothing else. And so something like that you might want to leave alone. But if you have a life insurance policy, such as ones that are out there where you can actually draw from it in retirements, then maybe that's when you want to have as a beneficiary, because whatever's left over, you want to make sure it goes to who you want to dictate it to. Okay, and then, so we just covered property, stock, life insurance. People put cars in trusts or not?
You can. California, really, one of the great things about our DMV, yes, I said that, they make it easy to transfer title on cars. Now, if your car is worth more than, right now we have our statute in California, they just changed the number. Thank you, California, for making this complicated.
Like, why not?
Assets outside of your trust that aren't planned for, if they're worth less than $208,850, they can be dealt with without going through probate.
Okay.
But we do have some clients who have automobiles that are worth more than that. We were probably going to put that in the trust. But another reason we don't is if someone sees trust on your registration, if you get in a car accident, their eyes light up. Oh my God, I've got a millionaire. I'm going to.
Right.
So we just make sure that for most people it doesn't happen. And there's still ways to say who's going to get it. But it's a simple affidavit process to change title in our state.
And I think that's important to distinguish, because, like, let's say your car, my car, we don't need to put that in a trust.
No.
But if you own a car that's a collectible and it was $500,000 or $200,000, then that's maybe where you want to be thinking about that. And then, of course, additional property, and if someone has expensive jewelry,
Yes. Yeah. We can list anything you want specifically. You can use a list that's something you can update on your own for more sentimental
items.
Yeah, property and memorabilia, things that might not have great value, but to the family they do.
Like ashes.
Yes.
Or diamonds that are made from ashes and you want that to be passed down generation to generation, something like that.
We work with our clients because those are the things. When I worked in court, we saw, people fought over houses, but you want to see what shatters families. It's sentimental things. So part of anybody who drafts a good trust is going to have these lists. It's referred to in the trust. The trustee has to follow it. It doesn't have to be notarized. You don't have to see the lawyer. It's something you can just constantly update. Sign, date. It's called incorporated by reference into your trust. And it allows you to really walk through the house or your apartment and think about who's going to get what and have that set in stone.
All right, so let's talk about what you mentioned and what I referenced earlier with the way the Rockefellers set up their trust with life insurance policies. So it kind of became a generational thing that just kept growing and growing. You said it's a little different. So it's not the traditional trust. Like, this conversation about trust is primarily to help everybody, with the basics so that you can get yourself started. It is so important, and it's one of the things that we tend to leave to the back burner and don't really address that we should. It should be as important as taking care of your driver's license every 4 years or something like that, making sure you have your affairs lined up in order so that money doesn't go to my most unfavorite thing, probate, which we'll talk about that again in a second. But before we get into that, there's books out there about the Rockefeller waterfall method and these sorts of things. How is that type of structure set up? And is that something that your everyday working person can do for their family to ensure some generational money?
They can. We call them dynasty trusts. And what people do is set things up. So if you have a married couple, it can be a single person, obviously, when they pass away, they aren't distributing to specific trusts, which is what we advise our clients to help protect their beneficiaries. They can all have what we call inheritance protection trust, but that's for an individual. Instead of doing that, they kind of set up a pot trust, this dynasty trust. Everything goes into it, and you set up the rules on how people can take money out, what they're entitled to. You have trustees watch over it. If the beneficiary is not the trustee, you get asset protection, something you can't get for yourself with most trusts, at least in California. So it offers a lot of ability to keep control, have even professionals managing everything, but still allowing your beneficiaries to, depending on how much is in it, to pay for school, buy a house, down payment. It depends on where you are in life. But to me, people who do what I do talk about leaving a legacy very often. But most of my clients aren't multimillionaires.
Right.
But if you think about it, I like to think about it this way. When you have someone in a family line, the first person to go to college, it's a big deal.
Right.
And they set a precedent for everybody to follow. Oh, we can do that. He did it, she did it, I can do that. When you set up your first trust in a family, it's sort of the same thing. It starts that little pebble rolling down the hill, getting some snow on it. And for each generation, once there's money there, and it's not there to go and live a lavish lifestyle. It's there for protection, to cover certain things that are important to the person who set everything up in the beginning. We have clients who say, this money's there if you want to try to start a business. And that's the sole purpose. Because they couldn't get money to do it, and they were successful, so they want to help the next generation do. It can be very specific like that.
I think that's one of the things that, again, using Rockefeller as an example, we see where some people saw this future planning opportunity of saying, okay, 5 generations down, my kids, what can, if I left, let's just use a small number, $40,000 in a trust, 5 generations down, where can that $40,000 be, right? And if I instill in my children, get life insurance policies, do this, add your assets in, and when they pass, maybe they had 2 homes and a life insurance policy of $100,000. Now you have $150,000, and then the property values of 2 homes. By the time that 5th generation, as you said, they could pull out for a business. They could pull out for borrowing from the trust for buying a home, or buying a home and putting it into the trust, so that keeps going, and it's in that way, like you said, it's that instrument of yourself. I think one of the biggest things that most people think about when they think trust is the topic we're going to get to next, avoiding probate. Probate is a nasty word for some people. For us as real estate agents, we're always like, oh, it's a probate sale, because that usually implies courts have to approve it. But when you're somebody that, let's just say your husband has passed, did not have a life insurance policy, did not have a living will, did not have anything lined up, and had no retirement but owned a home and had a business. Then what happens? Everything has to go to probate, right?
It does.
And then the person left behind has to hire an attorney to represent them in the probate?
And you could do it yourself. It's probably not advisable, but
Because you don't know what you don't know, and that's where we get in trouble.
yes. Yeah, I would think most people do work with an attorney on that. And just one little clarification. So if you have no planning at all, you pass away with significant assets, more than that $208,850, you're going to probate. If you use a will as your main instrument for planning, you're going to probate.
And they just enforce the will, right?
Yeah, probate means to approve the will. So in those two instances, you have to. A trust allows you to not go through probate because probate's all about changing title assets. If the assets are titled in the name of that trust, there's nothing for probate to do. So that's how, very quickly it avoids going through it. And probate, it's expensive, it takes a lot of time, and it's open to the public. So people take advantage of grieving families through the process.
So let's talk about that for a second. Like, how expensive? Because in my head, I'm like, ew, probate, I don't want the government to get any of my assets from whoever I want to give it to. Like, I don't want anything to be taken away. But is the true cost of probate what the courts do or the attorneys involved?
So the probate statute sets it up. Probate's expensive just to start. It's over $1,000. I think it's $435 for the petition. Then you're working with their investigators, probate court. It's another $600. I think just to get them started, it's over $1,000. I don't go to court anymore, so yeah, I spent 7 years working in mental health court, which is part of probate, and I was on the panel for probate court too. Now I don't go to court. I try to keep people out of court. That's my goal, that and keep families together. So the real expense, and it's laid out very specifically, there is a set percentage of the estate that goes to the attorney for the estate and a personal representative. And I can give you a brief overview. So you have your estate, they take the first 4% of the first $100,000 of the estate, 3% of the next $100,000, 2% of the next $800,000, and then 1% of the next $9 million, I think, and it just keeps this half percent. It builds
So it's
up
not as bad
quickly.
as I thought. Because I was thinking like 30%.
No. But this is a minimum amount that the attorney is entitled to if it's an uncontested smooth probate. Anything that gets in the way, they go to court and say, I've had to do extra. I want.
Wow. So in the case of, let's use this as a question and an example. If somebody had their own business, they had it as an LLC and they ran their own business, and it was a very small business, so it was like, they did mostly everything. They maybe had some outsourcing contractors that they would pay here and there, but they ran their own business and they pass away and they have a wife and they have kids from a previous marriage. So in a case like that, and maybe the wife was named as one of the C-level executives in the LLC paperwork. So in that case, where does that fall? Because in California, isn't like the wife entitled to 50%? Does that have to go to probate as a corporation and an asset? Like, what's the kind of nuances there?
So a corporate officer has no ownership unless the LLC operating agreement specifically lays out succession. Chances are this has to go through probate to figure out who's going to get what percentage. The children are entitled to a percentage, the spouse is entitled to a percentage, and so it goes to probate to figure out exactly who's going to get what.
And I think situations like that can get complicated really quickly because, using that example, so let's say someone had kids from a previous marriage, was married to someone else at the time that they passed, and had a small business that brought in some income. And let's say they're at retirement age and they want to continue that business so that they can live. Perhaps the children are like, yeah, I want them to make the money, but they also want to make sure that if that person, if and when they pass, that the business comes to them, or they maybe want to get involved. I can see where that can be very sensitive and maybe be taken the wrong way. Or in other times you'll have other siblings, let's say it's more than 2 siblings, but some siblings that will suddenly come out of the woodwork and be like, well, I want a piece of this because I want the money.
And all those heirs have to be notified that this is going through probate. And while it's in probate, it's not really being managed. No one's put in charge of it. So and that happens with homes as well. It's someone's got to pay property taxes, and where's that money coming from? So when something's stuck in probate, you're going to a judge all the time to ask for permission to do certain things with it, and it takes time to get in front of a judge. You're not always going to hear yes or no the first time you present something to them.
So you have to have permission from the judge to keep operating the business?
If there isn't anybody named to be in charge, yes.
Wow. This is way more complicated.
It can get very complex, and the longer people fight, the less control people have, unless an administrator's named.
If you are a homeowner and you're wondering if now is the time to sell your home, don't be afraid to schedule a consultation with me today. Let me share what we go over during that consultation. We take a walk through your home and you share with me the updates you've made. We talk about any deferred maintenance. I give you a fresh perspective of what the eyes of a buyer will see when looking at your home and the things that will make your home competitive to other homes on the market. We'll talk about what your potential list price is, what the value is you have in your home, and I'll really guide you through if now is the right time or if we should start to strategize about a certain specific time in the future. Because at the end of the day, this is your property, this is your investment, you have gained equity, and you have goals for yourself and your family. Simply click on the calendar link below. We'll get on the phone for a quick call, and then we'll set up that consultation.
So in that example, someone has a small business and they've done at least the bare minimum of setting up a corporation and all those kinds of things. If they have not named their successors in their articles of incorporation, it can get very hairy and even potentially affect that business from operating, because now
Absolutely.
Things have to be by permission of the courts. Now, is this one of these cases where they could keep the business operating and ask for forgiveness rather than permission? Or would they be penalized for still operating a business without the court's permission?
I don't want to step on judges.
Oh, I guess it depends, huh?
Yeah, I mean, no judge wants you to, for the business to fold. So,
Okay.
I mean, I think that you're going to get some leeway. They
Some reasonableness there.
Yeah, I would hope
Common
so.
sense, hopefully.
Yeah, I'll stay quiet.
Well, yeah.
But can I just mention quickly?
Yeah.
So if you don't do any succession planning in the corporate documents, if you use a trust, you can lay all of it out. You can have complete control. You do retitle the shares or the membership of if it's an LLC, the members. You retitle them to the name of the trust. You do an assignment to the trust, and now the trust controls distribution, everything, management, what you want to do.
So for all of you out there, and I'll even use real estate agents as an example, we are independent contractors. Some agents have themselves set up as an LLC and pay themselves out of that for tax purposes or whatever. But if you haven't done your estate planning and you set up a trust, you do want to make sure that goes into the trust as well.
It allows you, so if you have outstanding income that's supposed to come in, who's allowed to go and get it for you?
Yeah, that's the great question. Like, who cashes the checks? Who pays the debtors? Because I would assume if it goes to probate, when probate want to see all of the books and
100%.
decide is there outstanding debt, because I'm assuming this is an opportunity for people to come and say, hey, this person owes me money.
That's one of the main purposes, especially in California. One of the main purposes of probate is letting creditors know that someone's passed away and it's time. They have a certain amount of time to come to court and say somebody owes us money. And when you file a probate, the next step is taking out an ad basically in a newspaper it's going to be general circulation in the city where the decedent resided, and there's a certain amount of times it has to be done before probate actually begins.
It's interesting. My father recently passed away, and it's always amazes me who shows up first in the mail saying, send us proof of death. His mortgages have all sent letters wanting proof of death. And it's just like, how did you find this out so fast? Like and I know this just from a marketing perspective, because I've had clients when they buy a house, they call me panicking. I got this letter from someone saying I got qualified for this, or I owe this money. And I'm always like, okay, send me a screenshot, let me see it. No, that's marketing. Don't worry, you can throw it out. And so by the same token, there's companies have departments that watch public record, right?
Absolutely.
And it triggers something where they send out these generic letters to basically verify if someone has passed, right? And then decide the next steps.
There's also scam artists who follow the exact same thing. They can go and get the listings of all the probates. They're listed every day. You do the Daily Journal in LA County and go and see them right now online, and then you have the case number, you can go get the file. This is open to the public.
So how does someone protect themselves in that instance? For me, I'm always like I said, when my clients call me, I'm like, and my mom has done this too, where I'll be like, take a picture, let me see it.
Sure.
And because I've worked both as a mortgage lender and in real estate, I can look at something and say, okay, that's marketing, you can ignore that. But when you're grieving and you're overwhelmed and you're dealing with the emotions of losing someone, sorry, I'm starting to tear up here, and you get letters like this, especially if they sound like, if you don't do this, something's going to happen, it can be super overwhelming. How can you kind of weed through that and know or verify? Is it a matter of contacting the companies that you know are related to whatever that topic is? And at what point should people maybe like pause and not do anything?
You definitely need to. If you're grieving, the last thing you want to do is start speaking to anybody about money issues. You need time to process what's happening. Going back to a trust can help a lot.
Yeah.
With protecting, because you don't have to publicize that someone passed away. So it really can, it adds a layer of privacy that you can't get once you step into court. And that helps a lot. When I set families up, we retitle a house into the name of the trust. Before I can even email my clients and say, you're going to get these scam letters, they get scam letters saying, we want $119 to send you a copy of your deed. You're getting it. And I explain this, and I have copies in my notary book to show them, like, you're going to get these.
Yeah. I always give my clients a copy of the deeds too. I'm like, don't pay for it.
Yes, exactly.
I am sending you a copy.
The county sends it once you...
Yeah, there's that too. But, like you said,
look official, these documents.
There's marketing companies that send this. If you want a copy of your deed for $150, you will get blah, blah, blah. And I'm always like, no. I gave it to you already. Give me a moment. I'll send it to you again.
Absolutely.
Yeah. So it's a similar type of thing is what we're saying. Okay. I know I had some other questions that we can go over. Let's see. Okay, we did discuss that one. What are some other common scenarios that come up in estate planning that people should be aware of, or maybe isn't? For you, it's common because you do estate planning day after day, and it's something that somebody who's never done estate planning might not consider or might not have thought about.
Scenarios. That's a good one. Yeah. Every person I sit down with has a different scenario.
So is every structure different then too?
The basics of the foundation of the trust isn't, but when they're making decisions, they are. Picking, for one example, your healthcare directives. We do a comprehensive package. You should have all these different pieces. And they need to kind of work seamlessly together in the background to make sure you're covered every which way. For assets that don't go into a trust, how does somebody plan for incapacity? Durable power of attorney. It's a great document for that incapacity planning. But say on a healthcare directive, I have had clients who say, I'm going to name my agent, my daughter, she's a doctor. That's a great idea. She understands what's going on in the conversation, but think about it. And I don't want to change your mind, but just talk to her. And communication is so important in all this. You can have the greatest documents in the world, but if the family doesn't know beforehand what's happening, I have clients who say, should I tell the trustee, my successor trustee I'm naming them? No, you should ask the trustee. It's work.
Yeah, and I think there's times like, I'll use, sorry mom, my family as an example, like when my grandfather was really sick, my mother had to take power of attorney to be able to pay the bills on his house. When her brother got really sick, she did have medical durable power to not just execute the things he wanted, but to make those final decisions because he wasn't conscious.
Right.
And so, it's things like that that I think so often we don't properly prepare for. And had those things not been in place, what was already super difficult emotionally, because my mom was the oldest and she's been the most responsible in those kinds of things with her siblings, that burden has always fallen on her. But she, going through that with my grandfather, was prepared and learned and said, we've got to do these things and make sure they're in place. And even with her, my sister and I, we've had meetings over the last X amount of years to make sure that we're getting her set up as she's getting older.
And you all are all on the same page.
We're all on the same page, yeah, for the most part. The trust thing is something we also have to do, but we'll talk about that.
But the healthcare, right?
Yeah, the
So in my
healthcare,
family, I named my parents agents, and it took time. You're not just going to sit down and say what's important to you, what's quality of life mean. It's conversations. They're not fun. They're challenging. But with my mother, I learned what was important to her. Then I had that same conversation with my brother and my dad, all of us together. So if, God forbid, something happens, we're not questioning each other. I heard this. No, we're on the same page. We're making, the worst choices you ever have to make. But at least everybody's doing it together. And there's not what we see a lot of times when people name one person and maybe not, co-agents or something. You killed mom a couple years ago. You don't want things like that. We're thinking about the family.
Right.
And, your family is the family you choose. That's who's important to you. It's the people you care about. It doesn't have to be blood.
Right. Oh, that's true. You can pick, if you're somebody that your parents aren't alive and you don't have any siblings, it could be one of your closest friends, the person you trust the most in the world. I even think about stuff like, should I have my dog in a will as to who has possession of her if something happens to me? Things that we don't always think about.
And I go through that with clients. We rescued a cat, found out he was, a vet eventually told us something called pet dumping. People will, when they take over a home for a deceased parent, they don't want the pet, they drive like 40 minutes away, dump the animal so it can't find us. We got a cat that way. So with our clients, is it always important to have a trust set up for them? Not necessarily. You're going to put money into that and pay somebody to take care of it. But at least having a plan. Who's going to be there for that animal. If it's a cat or dog, we want something like that. We have clients with some of the bigger birds, tortoises in the area. They're going to outlive the clients. You have to have something in place. Plan. It doesn't have to be one of your inheritance protection trusts, but have something. It's a family member. To us, our pets are family.
Sure.
Make sure there's someone who's going to be willing to be responsible.
To be responsible, and that it's outlined in advance. And I think that's the biggest thing that with trust is it's about taking the time to plan for what happens next when you're not around to tell somebody what you want.
Or
right?
even if you're around,
but can't communicate for whatever reason. You're too sick, you're not strong, you're in a coma, you're incapacitated, like whatever the situation is. Like nobody wants to think about this, but if you were in an accident and hooked up to a machine on life support and you really have no function except for the machine is breathing for you, what would you today want to happen in that situation? Your loved ones are grieving, they're going through severe emotion. Some of that is maybe you'll pull through, maybe you'll come off despite whatever the doctors say. Like, what do you want to happen in that situation?
And those things are hard to really write out.
Yeah.
Unless you have a specific diagnosis. Your healthcare director is more general. It's the conversations that you have with people that are really important. And again, the communication between everybody involved matters just as much once you have the documents to make sure things don't end up in court. Because fights about this stuff, unless the documents were.
So we've kind of gone over a broad range of topics concerning trust. If you have not done estate planning, maybe it's overwhelming to you. I know someone personally that never wanted to touch this, think about it, talk about it, plan, which then always leaves the burden of whatever to those that love you the most that are left behind. What would be the next step? Does someone schedule an appointment with you? What do they need to do? I know because we've done some educational seminars together, and he does a lot of educational things. Tell people how they can prepare next and schedule something with you.
Thank you.
Yeah.
I think being informed, having basic understanding of how this all works is really important before you sit down with somebody. So I'm happy to meet with people. This is our home office or on Zoom for what we call a personal planning session, consultation. But we ask first that they either attend one of our educational seminars. We have a webinar, it's on demand. You can go to our website at any time. It's about an hour, and I tell a story about a family that goes through these life events, incapacity and death. So you see what happens in real life with people who plan the traditional way. Less than a third of all Americans plan at all. 80% of those who do use a will. So see what happens when you use a will as your main instrument, and then you do the same story but with a family, same family. They and we put them through a lot because they're going through all this incapacity death. They're a made-up family, though. It's okay. But then show you this comprehensive planning, how it changes everything. And if you're willing to invest that time, I want to give it back to you, and we sit down and apply what you learn in that to your situation and the context of your life to make it make sense.
Okay. Well, I have Seth's full contact information below. Again, we've done some educational seminars. Hopefully we can get more going on the book soon. I think this is such an important part, and it's not something that everyone thinks about. Just like financial education is not really taught in schools. I know for me, like we were talking about this off camera, like I didn't pick up and get very diligent about certain things because I was taught in school or my family did it. It was more, I don't want to say fear, but sometimes when you grow up a certain way and you observe things, you say to yourself, how can I make sure that my kids don't experience this, or that things are more organized and planned out, and if something happens to me, and it's just, not everyone thinks that way, but at some point, I'm gonna say this, if you're over the age of 30, you should be having this conversation with yourself first, conversation with your family, and meeting with a professional to get your paperwork and affairs in order, especially if you own property. And at the very least, I'm gonna say this, if you don't own property, but you have a 401k with work, or you have a life insurance policy separate, you need to really look at who your beneficiaries are. Don't leave those things blank. I've worked at jobs years ago where, people were going through the HR and were doing stuff, and people would be like, well, I don't know who to put, and HR would be like, oh, you can fill it out later. Do not leave those things blank. Pick someone. Whether it's someone closest to you, whether it's a family relation, just make sure you've got someone. You do not want to leave anything that has to do with value, money, or property up to a probate court to determine things. You want to make sure that your wishes are followed. So, any last words?
One quick one?
Yeah.
The most important document to me, for everybody over the age of 18, is get your advanced healthcare directive done. If you don't have this document and something happens to you, you can't speak for yourself, someone's got to go to court to get the right to make a decision for you. So get the document, have the tough conversations. Your loved one, get your healthcare directive done. You've set it up so someone can step in and manage things for you. If you don't do it, you're burdening people trying to figure it out. If you do it, your wishes are going to be carried out, and they're going to be able to focus on you and the court, not trying to make decisions, focus on what's really important, and that's saying goodbye to you, most likely.
Yeah, I mean, look, all of us go to bed expecting to wake up tomorrow. None of us expect to drive on the freeway and end up in an accident. These things happen, and they're unforeseen. And yeah, I agree. The best thing that you can do is make sure you do your basics. Now, let me ask this last question before I let you go.
Okay.
With a healthcare directive, is this something people can find online? Do they need an attorney?
No, you don't need an attorney. People like me, this is from court. I really found it to be important. I used to fight for families' rights to make these decisions because they didn't have healthcare directives. So it's the soapbox I'll jump on. I think it's just a great document. There in California, we have a statutory version. If you're part of a hospital group, everyone has a different version. There's something called 5 Wishes. It's really robust. It helps you think about different things. It's $5. You can order it from their website. There's a lot of different versions. Our website has a page with a whole bunch of them listed. Okay. It doesn't matter which one you choose, but
just make sure.
And it can be signed by 2 witnesses who are not family who are making decisions for you, or get it notarized. Either way, it's a pretty simple document. Name your agents and get that done.
Okay. Well, hopefully you guys, you have made your notes. There's some great tips in here, some things to really make sure you follow. I think the biggest takeaway outside of that is plan. You need to take the time to plan. We never know when something's going to happen, and I believe, especially since this happened recently, that it's not when you expect it. We're never really prepared, and so being prepared for the unprepared will help. And I just want to thank you for taking the time with me today, Seth.
Thank you so much for having me. I really appreciate you coming down here.
Yeah, of course. And everybody, more next time. But again, if you didn't take enough notes, watch this video over, and I'll see you again next time. If you haven't subscribed to my YouTube channel, take a moment to click the subscribe button and bell for updates.